Hi, I'm Denise and you're watching Law with Denise. This is a case summary of Chadwick and British Railways Board 1967. In this video, you will learn the facts of the case, the arguments put forward by both the plaintiff and the defendant, and you will learn the decision reached by the court. So what are the facts of the case? On December 4th, 1957, two trains collided near Lewisham in South London, England. Mr. Chadwick was living 200 yards away from the incident. And at 6 o'clock, upon hearing about the incident, he left his home to go and help victims of the disaster. Mr. Chadwick's wife said he returned home at 3 o'clock the next morning. And when he returned home, he was covered in mud and his hands were covered in blood. Mr. Chadwick went out again and he did not return home until 6 o'clock the next morning. When he returned home this time, his wife said he was clearly in mental distress. He was upset, he was shaken, and he wouldn't go to sleep. Following this incident, Mr. Chadwick's mental health deteriorated. Now, he was previously a cheerful person who ran his own window cleaning business. But following this incident, his mental health had clearly deteriorated. He needed hospital treatment for 6 months. Mr. Chadwick had developed anxiety neurosis. He had developed pure psychiatric harm as a result of his efforts to rescue victims who were part of the disaster which occurred on December 4th, 1957. What did the plaintiff argue? The argument put forward by the plaintiff was that the British Railways Board was liable for Mr. Chadwick's psychiatric injury. Why? Well, it was argued that as it was clear that the British Railways Board was negligent, and it was their negligence which led to the collision of the two trains on December 4th, 1957, and it was this negligence which led to the disaster, which forced Mr. Chadwick to go out and rescue others, which then led to his psychiatric harm. It was the British Railways Board which was responsible for his injury. Now, what did the defendants, the British Railways Board, argue? They argued that it was not reasonably foreseeable that an ordinary person would act as a rescuer and then develop psychiatric injury as a result of it. Yes, they recognized that they had been negligent, but their argument was that they did not owe Mr. Chadwick a duty of care because it was not reasonably foreseeable that he would, as an ordinary person, go out and act as a rescuer and as a result develop psychiatric harm. What did the court decide? The court decided that the Railways Board did owe a duty of care to Mr. Chadwick. They said it was reasonably foreseeable that an ordinary person would act as a rescuer, so would put themselves out and then perhaps develop injury. The court also said it was irrelevant if this injury was unphysical. They said it was possible to recover damages for pure psychiatric harm as a rescuer. Thank you.